On September 3rd, 2025, the California Occupational Safety and Health Administration, Cal OSHA, closed the comment period on its second draft of a proposed rule to regulate workplace violence. They've taken those comments and are preparing a third draft and believe that it will be released in spring of 2026, which will open up a new comment period. In the U.S. Occupational Safety and Health Administration, discussions have been underway for a number of years for an initiative to also propose a standard requiring employers to regulate violence in the workplace. We're going to discuss these regulatory developments in the field of workplace violence on this, the January 21, 2026 edition of the OSHA 3030. Welcome, everyone, to the OSHA 3030. I'm Manesh Rath. I'm an attorney at Keller and Heckman, a law firm here in Washington, D.C. We've been engaged in representing employers in the field of occupational safety and health law since the inception of the Occupational Safety and Health Act in 1970. I've been practicing representing employers for 30 years, and I'm joined today by my colleague and friend, Ben Idzik. Ben, welcome to the OSHA 3030.
It's good to be here, Manesh.
Yeah, it's good to have you here. And I think we got an important topic. It's been on the front burner for both the state agency, Cal OSHA, as well as at the U.S. Occupational Safety and Health Administration for a number of years. And in California, things seem to be progressing at pace to work towards a standard. So we ought to talk about what's happening at both, I think, the California level as well as the U.S. level, and give some background to this long journey for rulemaking on this particular subject of regulating workplace violence. Ben, in that light, why don't we start by talking about what we're going to talk about?
Yeah, absolutely. So we'll just start with a very quick intro to what's going on in California with the rulemaking that's currently ongoing there, how it came to be, and where its current status is. And then we'll, I think, dive into a brief overview of how workplace violence has been treated on the federal level by OSHA, and go through some letters of interpretation and other things that were issued.
And then I think we ought to get back into the details of where the California current proposal stands. What is it that they're proposing that employers will need to do?
Right. And then we'll finish it off with discussing, like you said, the proposal that's been pending before U.S. OSHA with respects to regulating it in the healthcare industry, and conclude, as always, with some practical takeaways for the OSHA 3030 community.
Right. So we begin with going back to, I think, 2023, California in the General Assembly passed a bill referred to as SB 553. And this bill directed the agency, Cal OSHA, to promulgate a rule which would require employers to regulate violence as a occupational hazard in the workplace. And it also directly required California employers to begin developing and to implement by July 2024 a written plan at their own workplaces, workplace specific, establishment specific written violence prevention plans that would identify hazards and create a plan for how to address those hazards.
Yeah, absolutely. And like you mentioned, that requirement has already been in place. The current rulemaking that's being undertaken is how to integrate that mandate into the broader system and have it be regulated by Cal OSHA.
Right. And the bill also, the act now also requires employers to maintain a separate log, not the incident, the injury and illness record-keeping log, but a separate log that records violent incidents, and that they maintain those logs for 5 years. So that's where we're at right now with California's rulemaking, and they're still in the process of implementing at the agency the requirement directed by the General Assembly to prepare a final standard interpreting that act.
Right. There's been a lot of back and forth between Cal OSHA and its standards boards to
Right.
get it to meet that deadline.
And a lot of input from the employer community.
Right.
Okay, why don't we talk about where the federal OSHA has been and where it's going with the question of workplace violence.
Yeah. So I think that the first time that federal OSHA really addressed the issue of workplace violence was back in 1992. They issued a very short letter of interpretation responding to an employer inquiry about, how whether or if OSHA regulates workplace violence. And the agency responded saying essentially that it's a very limited situation when it does. It said that workplace violence may be cited under the general duty clause if the violence was considered a workplace hazard. But it said that in general, random unforeseen acts of violence are not within OSHA's jurisdiction.
That's been their traditional position on violence generally, that if it's unforeseeable and that it is a random act of violence, that OSHA was never given the congressional mandate to regulate those kinds of unforeseeable, unpredictable acts of violence, and that it's not workplace oriented in nature. That's also, and we've talked about this. This is also something that they've stated in their field inspection reference manual or other compliance directive messaging from federal OSHA to its area offices. And so it's been a consistent position of theirs going forward through the 90s and the first part of the 2000s. Then in 2001, the Office of Inspector General for the Department of Labor issued a report. And in that report, they opined that OSHA should take some measures to assess the status of workplace violence in the workplaces uh, that it has jurisdiction over, and to determine what measures are within the agency's jurisdictional powers.
And I think also the report provided like an initiative to OSHA to put in place a measure to track incidents of workplace violence in the workplace.
Right, under the belief that the agency would not be able to manage what it couldn't measure, it directed the agency to start collecting data on the frequency or the forms or types of workplace violence and the sectors in which they were prevalent, more prevalent or less prevalent.
Right. And then 2017 was the first time that they issued a formal compliance directive, like you mentioned, Manish, where they essentially provided guidance to their compliance officers on how to address whether workplace violence was indeed a hazard in particular workplaces. And in this report, they provided examples of um, industries that OSHA wanted compliance officers to be on a particular lookout for. So they cited things like healthcare, for example, or late night retail, or transportation, taxi services, and that kind of thing. Things that pose an inherent risk to folks through the people that they interact
Right.
with.
Social services, if I recollect, they also uh, identified the prison system, both private and public.
Mhm.
These were areas where there was just a long track record where enough data was available so that the agency could reasonably conclude that future instances of violence in the workplace were reasonably foreseeable based on the prior record of data of incidents of violence. The other thing that OSHA addressed in the 2017 compliance directive was identifying the risk factors that it thought, based on the data it examined, were commonly associated with. Now, I'd point out not causative, but associative with past incidences of workplace violence. And they noted that handling cash, establishments where one person might be working alone at night and had cash on at the establishment, prior instances of violence at a particular establishment, which may be neighborhood by neighborhood specific, therefore, and not industry specific or the type of business that's being transmitted. And then a workplace that had a history of working with unstable individuals, and this would include the prison industry as well as healthcare, particularly for mental health. Then one more that they identified was contact with the general public. Ben, I thought that this was, even when I saw it in 2017, I thought that this was an unfair and unnecessarily broad attribution that work contact with the public leads to the reasonable foreseeability of the possibility of violence in the workplace is outrageous, because that would include almost every workplace. It's hard to imagine a establishment that doesn't have contact with the public unless it's a research station in the polar circle. So just to say that the mere fact that contact with the public is associated with workplace violence, while that may have seemed reasonable to the agency when it drafted that, it should have evaluated whether the opposite was also true, whether contact with the public was also associated with days without workplace violence, in which
Mm.
case they would have found, wow, there's a strong correlation with that too, and therefore no correlation at all. And so that one I take objection to, and I warn and ask our members of our OSHA 3030 community to keep an eye out for that one as the California rule develops. It's just unfairly overbroad to say that contact with the general public is a associated factor in workplace violence.
Then we have I think going off that point, Manish, would based upon these points that OSHA provided to its compliance officers, there were instances where the agency issued citations under the general duty clause for instances of workplace violence and how employers failed um, to abate the hazards posed to their employees. And a case that you covered in a previous OSHA 3030 episode back in 2019 was a landmark case in this regard. It was Secretary of Labor versus Integra Health Management. Um, and just to kind of give the folks a brief rundown of the facts, I'm sure we would encourage you to check out that episode for more details on it. But essentially, Integra employed folks who were coordinators, and these folks went out to the field and they conducted home visits with clients who had a history of mental illness. And in a particular instance, one of these coordinators went out to a client for a client visit, and this client had a history of violent behavior, violent threats, and unfortunately, the Integra employee was fatally stabbed. Um, and
Going back to the background of those facts, it's important to note that the administrative law judge found it relevant that that particular worker who had visited that house before had warned her supervisors that this person had demonstrated indicia of a probability of violence and asked that she be accompanied with a coworker.
Mm.
That request was declined. She also was a brand new employee who had, according to the testimony of the agency, little to no real training in how to address or how to deal with clients that had a high potential for violent conduct.
Yeah, no, I think those are great points, and I think though that showing that was made by OSHA led to this citation being issued under the general duty clause, and that citation being upheld ultimately by the Occupational Safety and Health Review Commission. So this practice was confirmed by this case. Um, and I think the last instance of the most recent sort of directive that was put out by OSHA was in 2023, which was a letter of interpretation. And that letter of interpretation went to OSHA's record keeping rule, what needs to be recorded on OSHA 300 logs. And the letter of interpretation said that if violence occurs at the workplace and work was a causal factor to that violence occurring, it must be reported on an OSHA 300 log, even if it was beyond the employer's control in that situation.
That's right. Meanwhile, I think it's interesting to note that Congress had about 4 or 5 years ago uh, held a hearing and evaluated whether or not OSHA was doing enough to progress its intention to promulgate a standard. And in that hearing, they had asked whether or not a standard could be promulgated by US OSHA that would be effective in requiring employers to develop standards regulating workplace violence. And it was particularly focused on the healthcare sector. Uh, at that congressional hearing, I was one of the witnesses asked to testify. There were witnesses who had testified as to the historical repeat prevalence of workplace violence, particularly in mental health facilities and in healthcare facilities generally. And the congressional committee concluded the hearings and directed the agency to proceed with its stated intention to develop a workplace violence standard that was focused on healthcare.
Right.
Uh, let's talk a little bit about the details about the California proposal. I
Yeah.
think that's really the one that's moving the fastest at this stage.
Absolutely. So the California rulemaking is focused, it applies to general industry. So unlike what we see with federal OSHA, which is specifically at this moment looking to put in place a standard for healthcare and social services, this one is applicable to most employees. There are some exemptions. I think one of the most prevalent one is that workers who voluntarily work remote are exempt from regulation under the standard. Um, but the current rulemaking is also focused on putting in place, and it has put in place in the latest draft, defining um, what does it mean by workplace violence hazards in the workplace? What are those things? And the latest draft provides 8 examples of what constitutes workplace violence that would trigger this standard to apply. Um, and it kind of has a lot of, like what we just discussed, Manish. It harkens back to a lot of things that were mentioned in the compliance directive that was put out in OSHA in 2017. Things like working alone, like you said, working in isolated locations, areas with poor illumination. Um,
Areas with poor illumination or blocked visibility, opportunity for stakeholders in the California process to comment that an area with blocked visibility does not have a statistical correlation to incidences of violence. Every workplace has areas with blocked visibility. Surely they must mean something more than the mere fact of blocked visibility to a particular location.
Yeah, it seems like, and going back to your point with contact with the general public, it seems like some of
Right.
these factors are just they kind of make sense on first look, but they are a little broad.
They need to be worded more carefully.
Right,
Yeah,
exactly.
yeah.
Right. So anyways, the regulations also clarify that these workplace violence prevention plans that were required by the bill will be enforced under Cal OSHA's jurisdiction. So if Cal OSHA comes into a site, among the things that they can request from you is the workplace violence prevention plan that you have to maintain. Um,
And in that plan, let's go through the 8 items because I think that those are important for our listening community. In in that plan, the employer has to consider all of the factors that could be potentially hazardous with respect to workplace violence. You mentioned working alone, areas of poor illumination or poor visibility, but also employers are supposed to examine their entryways and whether or not unauthorized access is permissible under their current layout, whether the workplace has effective escape routes. Some workplaces simply cannot develop effective escape routes, and that really does depend on the point of entry of the source of violence, which is unpredictable inherently. The presence of money or valuable goods, which again addresses every aspect of commerce that I can think of. There, even in a place where there isn't a cash sale transaction, let's say a construction site, of course there are enormously valuable pieces of equipment, and so there's always valuable goods where there isn't cash. Uh, Working late night or early morning, again, that addresses a very large fraction. Either working early in the morning or late at night pretty much covers everything. Selling, distributing, or providing alcohol, marijuana, or pharmaceutical drugs, I suppose that makes sense because that is sufficiently specific. But those that are not specific enough to identify an actual correlation between a workplace circumstance and a risk for violence need to be recrafted in the next draft to be sufficiently specific to be narrowly tailored to real risks for violence. And I would urge everyone listening to work with their associations. If you are a national company, a multi-state corporation, or a multinational corporation, work with your trade associations. You have a stake in what happens in the California rulemaking process, and work with multiple trade associations, anyone that you're a part of, to ask them to push back on areas of vagueness over breadth or ambiguity like the ones we just discussed. If you want to discuss them at greater length, contact us or have your trade association contact us, and we can share our views on where these, I think, poorly written elements uh, of the proposed standard could be improved before it goes into a final standard that we all have to live with. Then let's talk about you were mentioning the written prevention plan that employers are required to develop.
yeah.
Let's talk about that with a little more. detail.
Yeah, absolutely. So, like I said, one of the things so Cal OSHA will be enforcing that these plans are compliant with these regulations, and they include that these plans have to be written, they have to be site specific, and they have to be provided to employees during training and upon their request. I think training is a critical component of that. The regulations will require employers to provide training to new hires upon hire and then provide annual refresher training thereafter. Um, and there's also a record keeping provision that is in place that I think has some pretty standard record keeping requirements that employers have to go through.
It does, but the non-standard part of the record keeping, first of all, they're expecting employers to keep these records for 5 years. But in addition, the employer will need to create a record of any actual incident of violence, any near miss, any incident that leads to an injury or illness, and any incident that doesn't lead to any injuries or illnesses. And I think that the problem with collecting that kind of data and data that's so broad is that if the employer is overbroad in collecting that data, it will be used by a compliance officer to show that action should have been taken after that incident to change something about the workplace or its practices to reduce the risk of recurrence, despite its inherent unpredictability. And if the employer is not sufficiently overbroad in capturing that data, they could be cited for failure to record the data. So the concern that I have with the way it's currently drafted is specifically that it requires not only incidents that have led to injury or illness, but incidences that haven't, and incidences that could be qualified as near misses. I think that that's going to be tough for employers to comply with on a everyday basis. The other concern I have about the requirement is that as a subset of the training program, it requires preliminarily that employers engage in a hazard assessment. And here's where I think a lot of the problems are going to occur on a day-to-day basis for employers, and that our listeners in the OSHA 3030 community ought to go back to their trade associations with complaints about. The hazard assessment requirement, as it's currently drafted, requires employers to identify hazards based on an examination of their workplace and its practices, and based on uh, a pattern of past incidences, and that hazard assessment be reperformed anytime that there's an incident, a near miss, anytime that there's any operational changes, anytime that there's changes to the physical workplace. And this effectively results in employers being required to engage in a continuous improvement process where they'll never be free from the requirement to continually change their workplace violence prevention practices based on any change in their workplace, any change in their practice, any change in their record of incidences, or any change in their record of not having incidences, but there might have been a near miss. That inexorable zero, as Justice O'Connor referred to it, is an impossibility. And when you look at all of the other safety standards, all the other health standards, for example, have a threshold below which the standard doesn't apply. And safety standards have exemptions for everyday practices and a scope of applicability for which employers may conduct an evaluation and say that this is not applicable. This whole standard, all the requirements of the standard are not applicable. That doesn't exist here, and the idea that every single employer in general industry has to go through this continuous hazard assessment and continuous change, and that the possibility of even a single near miss incident although I don't think that's carefully defined, would qualify for requiring the employer to take action, puts the employer in an almost inevitable situation of being cited no matter what they do. And I think that needs to be improved in the California proposed rule before it goes on to its next draft. So for those of you participating who have operations that might be affected by the California rule, I would encourage you to work with your trade associations. For those of you who are in where one of the other members of that industry group might have operations in California, but you don't, I would still encourage you to support that, because historically we've seen on many occasions a rule developed in California first, and then when the US OSHA develops a rule, it embraces some of the elements of a California rule. In other words, the best way to fashion a reasonable, workable, livable rule addressing workplace violence in the federal system is to be vigilant at the state level in all the state plan states, including this one, which is moving pretty rapidly in California. All right, let's talk about the US proposal. Uh, what we see from 2016 going back as far as 2016, which is now, wow, about 10 years ago, nine to 10 years ago, is that the federal agency issued a request for information to solicit from stakeholders their feedback on workplace violence in specifically healthcare and social work.
OSHA then decided to initiate the rulemaking process, which began about in 2017. Um, and this process is still in the rulemaking stage, we would say. And notice of proposed rulemaking has not yet been issued. There has been a process to review OSHA's draft rule concepts that was reviewed under the Small Business Advocacy Review Act. But aside from the Sabrifa panel on this issue, the agency has not yet promulgated a notice of rulemaking. And um, in terms of the substance of the proposal, what we can glean from from what OSHA provided during the Sabrifa panel, is that it would be similar to what we discussed with California in terms of, but much more limited in scope and with being applicable to only healthcare. It will involve a mandatory standard, so it will not be not be voluntary. It will involve conducting hazard assessments, implementing controls, and providing training to employees.
Right, and it's very vague as to what controls the employer is supposed to be putting forth, and it puts the burden on the employer to make that determination and to conduct training accordingly. And I think that the concern with that our listeners in the OSHA 3030 community should be sensitive to is that without giving specific guidance to employers as to what is expected of them, employers will be left to try and figure out how much is enough and what measures are approved by OSHA and what measures are disapproved of by OSHA. Uh, that may not be a fair imposition at a regulatory stage, and I think that without guidance from the agency, employers should be given the benefit of the doubt that the measures they've taken are suitable to their risk assessment. Without any greater specificity, as we're currently seeing, I think employers are going to be required to take a hand in this rulemaking process through the comment process and give some feedback as to what kind of standard would work, what kind of standard employers could effectively implement that is more than just employers have to develop a written plan and conduct some training. That I think is not going to be good enough. I think, Ben, it's safe to say we and the employer community that we work with are supportive of the idea that violence in the workplace with respect to healthcare and social work is an important issue. And the employers that we have spoken with are, I think, by and large, taking extraordinary measures to try and reduce that risk. But as has been noted by administrative law judges and by the agency itself in its interpretive guidance over the past several decades, violence in the workplace is most of the time inherently unpredictable, inherently random, and it's outside of the province of most employers to have the expertise to deal with law enforcement issues. So clearly, it's an important issue. Clearly, to confine this to the healthcare and social work environment is a reasonable first measure where we believe it's a known risk.
Mhm.
With that in mind, let's talk about what we think employers should do.
Yeah, definitely. I think uh, in light of this whole discussion, we can see at least that there is some movement, definitely in California, which is fast and motivated by their statutory deadline. There is movement in this field to regulate workplace violence. So I think a practical thing that employers can do even now is start thinking about and ultimately implement some kind of workable policies and procedures to address violence in your workplaces. And have it be done before any sort of unilateral mandates from US OSHA or the states.
Right. And I think that policy, the first step before implementing a policy is to conduct a hazard assessment. Every employer, every workplace ought to conduct a hazard assessment as to the possible risks associated with violence in the workplace and evaluate whether or not their current security measures are sufficient to address those risks. And I do think that that is something that employers should do periodically and should learn from employers in their own neighborhood and other employers in their own industry or a line of business as to what risks or what incidents they've experienced and what interventional measures or preventative measures those other employers are implementing to learn from a community, whether that community is a geographic neighborhood or an industry group. I think is an important exercise for all employers, regardless of whether it's in healthcare or other elements of general industry. And I think that's implementing a policy starts with that hazard assessment process.
I think another thing to keep in mind is going back to what we discussed with how citations for in this field can be issued under the general duty clause. Just keep in mind that an employee's prior history of violence or threats may be used as evidence to show that violence was indeed recognized in your workplace.
I think that's a reasonable premise. There's a centuries-old premise in tort law that every dog is entitled to one bite, and employers need to learn from their own experiences. And if they take no action despite having had a prior instance of violence in the workplace, I think that that is an argument that the employer had enough knowledge that they had a duty of care to exercise some preventative measure in the future.
Definitely. It's exactly like what we discussed with the Integra case, falls right square into that. And I think going off that point, Manish, we can also say that when violent incidents or threats of violence incidents occur, it's important to document those incidents and take and show OSHA, which might provide some scrutiny on the steps that we're taking to mitigate the hazard.
Right. And I think that the last two things that we would want to share as potential steps employers can take in this particular era where these two rules are being developed and have not yet been fully promulgated is to work with your hiring process to engage in background screenings to find indicia of the potential for violent conduct in the workplace. Although that does not represent by any means a significant fraction of incidences in workplace violence, it is nevertheless one measure employers can take is to engage in more vigorous background checks. A lot of employers, the trend has actually been a decline in background checks. And I think that that would eventually lead to a slight increase in workplace violence incidents. And the other is to develop a partnership with law enforcement to have that open communication to report incidents or threats of possible workplace violence and to learn from your law enforcement agency what else has been happening elsewhere in the neighborhood. Valuable information can be exchanged in both directions by maintaining a positive relationship with your local law enforcement agencies. With that said, that is today's OSHA 3030. Our next OSHA 3030 will be at 1 p.m. on February 18th, 2026. We have sister programs February 25th at 10 a.m. for the Reach 3030 and at 1 p.m. for the Tosca 3030. Please tune into those. As always, we're thankful to those of you who, when you receive your email invitation for any of these three programs, to forward it on to at least three others within your organization and at other organizations. Anyone responsible for maintaining workplace safety and health or these other two statutory schema, both as safety professionals or in-house counsel, so that we can continue to expand the number of people who we embrace in the OSHA 3030 community. And we're thankful to you for having done so in the past. Please continue to do so in the future. I want to thank everyone here at Keller and Heckman as well who helped produce this edition of the OSHA 3030. Thank my friend Ben Idzik for helping put this program together, and we look forward to seeing you all again February 18th for another round of the OSHA 3030. And until then, stay safe.